If your petition involves children, the court may require that you and the other party attend a co-parenting workshop. This is a short session, usually about 4 hours, designed to help you help your children through the divorce process. You and the other party may not agree on one other single thing, but one thing you can agree on is a common goal of creating a healthy, happy home life for your children. There will be a fee for this workshop, but if you fall within certain income guidelines, you may qualify for a reduced rate. You will need to provide your specific case number when you sign up for this class. Most providers will send notice to the court after you've completed the class, but some counties will require you to submit your certificate of course completion to the court. Check with the court to find out if you need to submit proof after finishing the class. If you are filing a protective order against the other party, let your class provider know so that they do not schedule both of you for the same class session. Some courts require parties to complete work on the following websites: www.uptoparents.org for parents seeking a divorce, or www.proudtoparent.org for unmarried parents in paternity cases. Each of the websites represents a chance for parents to take a time out from this often difficult situation and consider 50 commitments they can make to their children during this time of conflict and stress. Even if your court does not require this website work, you can gain important information from these or other similar websites. Sites that will help you and the other party work together to place the first and greatest priority on your children. You may also ask the court to appoint a representative, known as a guardian ad litem, also known as a GAL, or a court-appointed special advocate, also called a CASA, to speak for the best interests of your children in this case. The GAL or CASA's role is to speak to you and to the children, and then to make recommendations to the court regarding the issues considered to be in the best interest of your children in terms of custody, parenting time, and other matters. However, there is usually a cost to you for these services. Having a judge make decisions about the time you will spend with your children can be very stressful. Instead of simply going to court and hoping the judge will rule your way, you can choose to be a part of the decision-making process. Mediation and other forms of alternative dispute resolution, or ADR, involve a specially trained, neutral third party who will help you work out an agreement without going to court. Mediators don't take sides. They will not make decisions for you, provide legal advice, or recommend the terms of an agreement. It's the mediator's job to help you reach solutions that both sides can live with. You have nothing to lose by trying mediation or other forms of ADR. If you can't reach an agreement, you can still go to court and have the judge decide. Mediators and facilitators charge for their services, but many counties have programs to provide these services at little or no cost to you. Ask the court if they have one of these programs or if there is a list of mediators who are willing to take cases at a reduced cost. You and the other party are in the best position to know what works best for you and your children. Mediation and other forms of ADR help you participate in the decision-making. The solutions you come up with together are more likely to avoid conflict in the future. Like all states, Indiana requires both parents to support their children, even if the parents don't live together. The amount of child support depends mainly on each parent's income and other resources, and how much time each parent spends with the children. The court makes these decisions based on the information that you and the other party provide. This information is provided on a form known as a child support worksheet. The Indiana Supreme Court provides an online child support calculator to help you compute how much child support you or the other party will have to pay in your case. This step-by-step guide can be found online as shown on your screen. This website will use the information you enter to automatically generate a child support worksheet that you must file with the court. It's up to you to complete a child support worksheet before your final hearing date. You must bring it with you to court, along with a copy for your own records and a copy for the other party. If you don't provide the court with a completed child support worksheet, the court may not hear your case on the scheduled date, and your case may be delayed. What children need and how they cope with their parents living apart changes as they mature. Keep this in mind as you plan for the time you and the other party will spend with your children. The court refers to this as parenting time. Try to be flexible and build a parenting time agreement that meets the needs of your children and your family situation. The Indiana Parenting Time Guidelines are designed to help parents and courts put together parenting plans that are in the child's best interest. Remember that the guidelines set forth the minimum time a parent should keep regular and meaningful contact with a child. Scheduling parenting time can be difficult when two separate households are involved. It will take effort and communication between both parents. Even if you and the other parent cannot agree on anything else, a little give and take on parenting time arrangements can mean a lot to your children.